Good morning to both of you. Today's date is June 9th, and we have a number of Zoom arguments. And Attorney Kelly, you're on all three of them, actually. And Attorney DiMatrino, you're on the first one, and then Attorney Corrigan is going to follow up with the next two. As you can see, the panel this morning is Judge Carr, Judge Callahan, and myself. I'll be presiding. So the appellant, of course, can reserve up to 5 minutes of their 15 minutes for rebuttal. I'll be keeping track of time, so let me know if that's how much time you would like to reserve, and I'll let you know where you're at. May interrupt you to let you know that you're getting into that time. You both have argued a number of times, so you know the rule that we do not, we would ask that you not use the names of children or victims during your argument. Keep your voice up since we are being recorded. I can assure you, Judge Callahan, Judge Carr, and I have read the brief, so we are prepared to proceed if you are. And the first case is 30079 State versus Stefanko. Attorney Kelly, would you like to reserve some time?
I would like to reserve 5 minutes, Your Honor.
All right. As I said, I'll let you know as you get close, but you may
appreciate it. Thank you, Your Honor. May it please the court, Attorney Angie Kelly on behalf of the appellant, Erica Stefanko. The first issue for the court's consideration today is whether or not the appellant's right to due process of law, and specifically her right to confront witnesses, was violated by the trial court due to their COVID-19 procedures that they had in place. I know the court is familiar with due process and that it is a flexible concept depending on the importance of the attached interest. And in this case, we're talking about the interest of life incarceration, which is certainly extremely important as it relates. This is procedural due process claim, and the procedural due process in the realm of criminal defense would be mostly what's contained in the Bill of Rights, and this specifically would be the Sixth Amendment of the Constitution and the Confrontation Clause. Confrontation Clause has a primary purpose of the right to cross-examine and to observe the proceedings. There is a preference for face-to-face observation in both the federal courts as well as under the Ohio Constitution. However, there are circumstances in which that can be weighed against public policy and not be a necessity for a specific trial. What Ohio courts have basically said is that face-to-face, no face-to-face may be all right if it's necessary to further in public court and policy. There's reliability of the testimony, it's under oath, subject to cross-examination, and there's an opportunity for the judge, the jury, and the defendant to view the witness and their demeanor as they testify. At issue in this particular case, I would say are three. One, masked witnesses, which I will acknowledge trial counsel did not object to. Two, video witnesses, and a video witness who was wearing a mask because he was in the Ohio Department of Corrections. I'd like to focus on really Mr. Cobb's testimony, as he was the primary witness against my client in this case. He is incarcerated, serving life in prison for murder, and appeared via video. There was, in fact, a motion filed by the state of Ohio to have him transported, which was denied by the court. I believe that was back in September, and the trial didn't proceed until the end of November. This is a very fluid area of the law since it is a unique issue. COVID hasn't been around long enough for all areas to come forward. I would urge the court to review and to follow the logic under the Missouri Supreme Court's decision in Cara versus Jackson County. As the state pointed out, I do recognize that is not binding authority on this court. However, there is no binding authority on this court that I can find at this time. Further review since the drafting of this brief, as well as in preparation for today's argument, there have been some additional cases across the country that have come out on this issue, and it does appear as though the vast majority of courts have been following the same reasoning that the Missouri Supreme Court used in the Cara decision. And I also feel that this is a great case in order for the court to analyze the specific issues in this particular case, because the court did such a nice job of going through the history and the jurisprudence of the Confrontation Clause and what different ways courts across our country have been interpreting it in regards to this specific issue. And in that respect, there have been basically three different ways that courts have been analyzing it. One would be under Maryland versus Craig, which is what the majority of states and jurisdictions, both federal and state, that have looked at this have decided. Under Maryland versus Craig, there needs to be a case-specific analysis of necessity and witness-specific findings. That is, in fact, what the Kara court adopted. However, just so the court's aware, the other two positions that courts have been taking would be U.S. versus Gigante, which allows video upon a finding of, quote, exceptional circumstances, and Crawford versus Washington, which is the right is absolute for evidence unless witness unavailability and prior opportunity for cross-examination has taken place. There is some discussion and question as to whether or not Craig is still good law because of Crawford. However, it has not been expressly overruled. And as I stated, the majority of courts in this country have been utilizing it for this specific purpose. And in
Counsel,
fact, yes.
Counsel, yes, I just wanted to ask you, obviously with everything that was going on with the global pandemic, the Supreme Court as well as the local courts issued certain orders, and obviously that impacted how things would be handled differently than they were before. So when you say there's really no case law in regard to the videotaping, or not the videotape, but the video appearance and so forth, weren't those issues handled through the court orders?
No, I don't believe so. I'm like, they're not specific to particular jury trials, and it's my recollection that most of the orders that were issued from the Ohio Supreme Court specifically stated that it was when it was feasible and when it would secure the proceedings.
Well, and that's what I'm saying. They did allow for it to happen, though.
Under certain circumstances, yes. I'm like, but in this particular analysis, what courts are looking at is whether or not the court looked at an individualized rationale for that specific witness not being available. Like initially when I was reading case law, what I was seeing was a lot of courts were just automatically saying, oh, child witness can do closed circuits, so we can do adults. But that's not really what the case law says in other jurisdictions. In those cases, like, for example, I know I looked at one case where they allowed adult witnesses to testify via closed circuit television prior to COVID, but that's because they were being threatened in order to like not attend the trial. So it was a safety issue. What the court did was a case specific analysis. I mean, this court in particular held that those specific findings have to be verified because generalized concerns about the virus may not override the individual's right to confront an adverse witness. And our position is that the court is completely accurate on that, in that what our court was required to do, particularly as it relates to Mr. Cobb, was to make case-specific or witness-specific findings as to why his testimony would create any additional risk that any other witness wouldn't. Because as the court knows, this is a case where it was like a hybrid. Some people were coming in person, some people were coming in on video. They were kind of flip-flopping back and forth between the two. But even the cases that I've been seeing since drafting this brief that have been being released, in some in Ohio, not in our particular jurisdiction, what they're finding is that the courts are going through and they're saying, okay, this particular person has health issues. We received a note from their doctor. They create a significant risk to their health as a result of coming in. Therefore, we find the public policy mandates this to happen. I know in this instance, the court said, well, he's in prison. It might be hard to get him transported back, but they didn't make any effort to do that. I mean, the reality of the situation is that any discussions that were had about it were over 2 months prior to the trial actually taking place. And those discussions didn't specifically state why he would increase any risk or cause any additional risk than any other person that was coming in. I mean, the defendant made it very clear that she wanted him to be there in person so that she could confront him. Like, if you review the entire case as a whole, the COVID concerns are very random in the way that they are effectuated and how this trial was handled. I mean, at the start of the case, everybody was talking about right before they started trial that the numbers were up. And as we all know, COVID was very fluid. Some months it was more dangerous than others based on the numbers in the community. The day the trial was supposed to start, numbers are up. The state actually asked to continue the trial. The court said no. So obviously it didn't feel that the trial was too big of an issue for them, even though the numbers were going up. There was one witness who worked for BCI who had a possible, Yes.
Oh, good. Okay. I thought I was muted. On that issue with the numbers going up, and you are certainly aware that there's a couple of cases on that issue today because you're on them. Wasn't there an administrative order that says speedy trial cases can go forward?
This was not a speedy trial case. She
That was
executed
my
a valid,
question. All
this is
right.
not a speedy trial case.
And
But
the
yes, you're
defense,
correct.
the defense asked for a continuance, correct?
The defense did not, the state did.
Okay.
It was actually the state that asked for a continuance and or to shift it to a video because they were concerned about the trial going forward with the numbers increasing, and the court declined.
Did the defense object?
I think he did, but as I stated, there was no speedy trial issue because she executed that waiver back in 2019 and it was
Okay.
valid and filed with the court. So speedy trial was never an issue in this case.
And as to the transport of Ms. Cobb, was there ever any testimony or anything put on the record from the sheriff or anyone from Summit County Jail that basically would have validated the fact that he could not be transported to the Summit County Jail?
No, there was nothing done like that.
Okay.
In regards to him, just a very generalized statement from the trial judge stating it was too dangerous.
Okay.
Attorney
Thank you.
Kelly, you are at that 5-minute mark. And did you have another follow-up,
No.
Judge?
No.
Okay.
Okay.
Would you like to continue or would you like to reserve that 5 minutes?
I'll reserve the 5 minutes.
All right. Thank you very much. Attorney DiMartino, 15 minutes.
Yes, thank you. May it please the court, Heaven DiMartino, on behalf of the appellee, the state of Ohio, we are asking this court to affirm the aggravated murder conviction for Erica Stefanko relating to the death of Ashley Biggs on June 20th, 2012, because the verdict is supported by the weight of the evidence. She was represented by effective counsel. The court did not err in declining to grant a new trial. The court did not err in admitting the emails that Ms. Stefanko sent to Ms. Dunson, and the trial court did not deny Ms. Stefanko's rights by allowing individuals to testify with masks on and to allow video testimony. So getting to that first assignment of error that goes to the issue of the confrontation clause and whether or not those rights were infringed by witnesses wearing masks and or being permitted to testify by video, the state does point out, as Ms. Keeley acknowledged, that there was no objection at the trial court with regard to the mask mandate. So that is waived. There's no plain error argument raised here, so the court does not need to engage in that analysis. Beyond that, there's an 11th district case, State versus Hadlock, that came out in 2020 that says masks do not infringe on a confrontation clause right, and that body language is more than just what's covered by, a piece of cloth that would cover a mask. And there was a public health interest.
Counsel, but isn't that case, it wasn't a videotape with a witness wearing a mask?
No, it was masks in
That
general.
is a huge difference here.
So the issue with regard to the video, and I agree, we're talking people who are in the courtroom with masks is what the case law that has come out so far. But I don't think that would be any different, honestly, than testifying by video. Video testimony is permitted. There's case law supporting video testimony. There was a public health issue, and there was administrative orders in place that did talk about what cases were permitted to go, and also talked about transportation of witnesses by the sheriff's office. And that is reflected in the record when the court talked about the fact that because Mr. Cobb was in prison, he would eventually come to the jail, which would put him within the purview of the Summit County Sheriff's Office, which was not doing transports at the time.
Well,
So that all went into
counsel, on that issue, with that administrative order, this case didn't need to go at that time. Would that be correct?
the case did not have to go, but the administrative judge, who was the presiding judge on this case, wanted the case to go forward, and it went forward. It was not within the speedy trial deadline that had to go forward. That is correct.
Does it make a difference? And I'm gonna add on to what Judge Carr just asked. You have mask and video, and add on to that what I will call a chopped up opportunity to cross-examine. Now you have all three of those things going on.
I don't see, so one, the issue with the mask is waived. So there's that. But two, there's no evidence in the record that there was any issue with understanding Mr. Cobb, that there was any issue with the fact that the testimony was, I'll use your word, chopped as far as the cross-examination went. And there's overwhelming evidence in this case beyond just that Mr. Cobb said that Erica ordered the pizza and Ashley didn't leave that field alive. There's other evidence in this case that even if you took out the testimony of Mr. Cobb, it wouldn't be an issue. Furthermore, with regard to the video appearance, they didn't object either, like I said, to say, well, not only is Mr. Cobb testifying by video, but he's also wearing a mask. That wasn't raised at the trial court below, so it's waived. But the case,
counsel, I'm sorry, it's hard when you're doing it via video. I don't mean to interrupt you, but they did object, didn't they, to his appearance via video?
just by video, not by wearing a mask and being on video. So the only thing that's before the court is the issue of whether video testimony was permissible in this case. And when she talks about the Cara case is the case that added the requirement that you put specific findings for specific witnesses. That's not the case out of Craig and the holdings out of Craig. And as appellant counsel acknowledges, Craig is what is being followed by most courts. And that just requires that there be an interest, this public health interest, and that the testimony be reliable. There's nothing in the record here to support the speculation and the conjecture that because he testified by video and with the mask, there was any inability by the jury to determine his credibility. They already knew he was in custody because he pled to the murder of this victim. They knew that he had previously been married to this defendant. All those things were there. I mean, the things that they would use to determine credibility that are in the record are in the record. These other things that counsel is arguing is all speculation and conjecture. There's nothing in the record.
The things that they would use to determine credibility. I mean, okay, you have an eye roll maybe. Okay, you can see that on video and mask, but what about, feet shuffling, hands fidgeting? I mean, so many things go to the whole person. I'm not sure, and I understand that there wasn't an objection to mask, but can you separate the mask and the video when you had counsel objecting to remote testimony, period?
Absolutely. You could say, not only do I object to this person testifying by video, but if they're going to testify by video, then I would like them to take off their mask. And they did not say that. And counsel could have put into the record, for the record, since this is on video, I would like to note that there is feet shuffling, that there is eye rolling. None of that is in the record. It is completely speculation. There could have been at any point a sidebar, any effort made to put into the record that there was something going on, if there was something going on, that wasn't being captured by the jury, and that's just not there. And
okay, on that, let me ask you, maybe I misunderstand as to what could be seen from the video. I'm assuming it's something like what I see with you two right now and my colleagues. Was it a whole body? I mean, do we even know that from the record?
From the record, I don't think so. Just looking at what's in the record, I do not believe there's anything in the record that would tell you how much of each person that was testifying on video is captured in the record. And that would be, again, the appellant's burden to get any additional information in the record, and it is not in there. So the state would argue that in light of the case law and in light of the epidemic and the overwhelming majority of the cases that find that video appearance does not infringe on the confrontation clause, and that you just need to have the finding that there is this health issue and that otherwise the testimony here was reliable. The Cara case wasn't even binding in Missouri on adult cases. It related to a juvenile case that was excluded from the pandemic rules. So in Missouri, they said the juvenile cases, you can't do them by video. And because of that, if you have a witness that's going to testify in a juvenile case, we want the specific finding that this particular witness has to testify by video. So it wouldn't even be binding in that state, let alone in this state. And there's no cases that, support that in this state. With regard to the new trial at the trial court level, it was filed 34 days after verdict, so it was untimely. It also only raised the issue of alleged speculation about coercion because the Howard charge was given close to the holidays. There was no anything in the record argument as far as whether or not Ms. Stefanko was there or there was some harm because she wasn't there. So those issues that are being argued here are beyond what's in the scope of the record. With regard to the emails that were sent to Ms. Dunson, those were sent by the appellant. They came in to show the effect on the person who received it, Ms. Dunson, and they were also admissions by a party opponent. They weren't admitted for the truth of the matter asserted, and contrary to the case law that was cited, where the person who got the email didn't testify, here the person who got the email testified about the emails, and there's no issue with regard to authentication. With regard to the issue
I'm sorry, go back to what you said about authentication. Did you say no issue with regard to authentication?
Not like there was in the other case. In the other case, they said, how can we authenticate this email? The person who sent it and the person who received it didn't testify about it. Here, the person who received the email said, I got these emails and I got them from the appellant. That was the testimony. So that is different from the case law that's cited.
And again, we don't have the record yet going for the briefs. I thought the person who testified about the email was told that that's what the email said.
I believe it was the person who got the email. I would have to go back to double check, but that was my recollection. I would have to go back. I can look at the brief in a minute.
Just to make sure I'm on the same page, the email itself was never before the jury or admitted into evidence. Is that correct?
That's correct.
Okay, thank you.
And with regard then to, again, I'm just going to go through the manifest weight real quickly, and then I know I'm running short on time, but
you have about 5 minutes left.
Okay, so because I know there is an issue about talking about Chad Cobb and his testimony, it was not obviously the only evidence that came in with regard to who committed this offense. So Cindy Cobb, who is the mother of Chad Cobb, testified that in 2012 there were custody issues. So the child GC, who also testified, at that time the mother had gotten temporary custody, which was causing a lot of issues. And at that point, there was the ongoing issues that was in the record. So in 2014, which is after Mr. Cobb was convicted, and it is after the two of them had divorced, Cindy Cobb testified that Erica Stefanko told her that she was the person who ordered the pizza and she doesn't feel bad that Ashley is dead. Chad testified about the fact that that Erica is the one who ordered the pizza, testified that she dropped him off where the pizza was delivered, that Ashley did not leave that location alive. He testified that he basically left the scene of where they left the body together with Erica and went home. The child GC testified that she heard Erica that night order a pizza. And the type of pizza and all those things that are in there to show lack of, there's some kind of disconnection. I mean, the pizza was a ruse then, it's a ruse now. Nobody, the pizza was just the vehicle that got Ashley to the place where she was murdered. Mary Brinkman testified that she had Ms. Stefanko over for dinner a few times, and she talked about dropping off Chad and picking him back up afterwards, and talked about how if the corn in the field had only grown a little bit higher, she never would have gotten caught. And then of course there's the blood evidence. There's blood in the field, in the area where the pizza was delivered. The body was found in the cornfield, and there was blood found at Chad's at home. So based on that, the state would ask this court affirm the conviction for aggravated murder. And if there are no other questions, I would rest on the brief.
Judge Callahan, any further questions?
No.
Judge Carr?
No, thank you.
All right, thank you for the argument. Attorney Kelly, you'll have that 5 minutes.
Thank you, Your Honor. Just to briefly touch on a few things that were addressed by the state. She said that there was no issue of not being able to understand Mr. Cobb. That is not an accurate statement. At the very beginning of the cross-examination by trial counsel, both Mr. Cobb as well as trial counsel both stated that there were issues with the connection and they were having difficulty understanding each other. And I apologize, I was trying to find the exact citation. This volume is huge. So I can't locate the exact page, but I do remember being within the first couple of pages of the cross-examination of Mr. Cobb, and that taking place between the two of them, and there not really being anything done by the court to address that, or whether or not it had been corrected at any time. So I do think that that is an issue. In regards to the Craig case does say that the court is required to make case-specific findings. That's U.S. Supreme Court. Yes.
I don't have a lot of time. I'm just curious. Would you agree that the attorney, whenever he made his objection, the defense attorney, that he did to the video testimony of Mr. Cobb, do you agree that he did not object and say he shouldn't be wearing a mask?
He did not specifically state that, no.
Okay.
I have
And
to agree with that.
okay. Do you agree that that makes a difference?
No,
Okay, why not?
I don't think it specifically makes a difference, because I think that an objection correctly preserves everything related to the testimony of that individual witness.
Do
I
you
would
know?
argue that
Yeah, go ahead. I'm sorry.
I mean, I guess my position would be, oftentimes in court, if somebody brings it, it's kind of the same way as like with the emails, there's an argument by the state that because Mr. O'Brien objected and he said hearsay, that doesn't preserve the issue of whether or not there's authenticity for those emails. And I would respectfully disagree. Oftentimes in trial, the objection itself is what preserves it. We don't have to lay out every specific potential legal argument that could be related to that specific instance. So I would say I'm sorry.
I think the case law is if it's obvious from the circumstance as to what the objection would be.
Correct.
So the fact that other witnesses had testified in without objection wearing mask, would that implicate the circumstances under which the objection was made?
That's a good question. My position would be no. The court may find to disagree with me on that, but mine would be no. Unfortunately, the state is correct in that we don't have anything in the record that verifies that. And I do know that sometimes this court is, public record can be available to the court. I know what he looked like because this was a live broadcast trial, which is not common, but that is not part of what the appellate record indicates as to how he goes. I think that it kind of goes without saying that the mask is also an issue when it comes to Mr. Cobb, and definitely in regards to his ability to not be understood. Now, as in regards to Kara being a juvenile case, I'm aware of that. And juveniles have a right to confrontation under the United States Constitution the exact same way that adults do in the criminal justice system. There is no difference there. The state's making an issue of the fact that the Missouri state didn't have a specific order as it relates to juveniles, and that's not what I'm asking this court to do. I'm asking this court to look at the legal analysis of the confrontation issue within that case and follow the same line of reasoning, that there needs to be case-specific analysis for any witness to testify via video, or else it's a violation of an individual's right to confront a witness under both the US and the Ohio constitutions, because the law really is very similar and parallel between those two. Even though Ohio specifically says face-to-face, the case law is very parallel. In regards to very quickly, the emails, since she talked about the emails, the girl who got the emails did not testify. The woman who received the emails was the decedent in this case, allegedly. The testimony came from a Miss Dutton, who was her significant other at the time of her death. And her testimony was such that she saw or was told, she only acknowledged seeing one, otherwise was told about emails that took place between the decedent and the appellant. There was no evidence offered as to what email address those emails came from, no verification that they actually existed, how many of them she had actually seen, how many of them there actually were, what the dates of those emails were. I know at one point she gave some testimony that said that the email had come before she even knew the decedent. So she's just hearing about something years later. As it relates to that objection, as I was saying earlier, I think it's the same issue. I mean, technically, trial counsel said hearsay, but everything encompassed in that objection would be. And I actually think that the bigger issue in that is the authentication of those emails and whether or not they actually existed, because there was no evidence that was offered to authenticate them or who they came from or whether or not they had any link to the appellant in this issue.
And with that, Attorney Kelly, your 5 minutes is up. We want to
Okay.
thank both of you for your arguments here today. Attorney Kelly, you're going to stay with us, I think. And
You're stuck with me all morning, Judge.
for the next arguments. Attorney DiMartino, again, thank you for your arguments. We'll take the matter under advisement, issue a decision in due course. Each of you will receive a copy of the decision, which will be mailed to you on the date it's released, and you can also find the opinion on the Supreme Court of Ohio's website.